subtle difference between the legal fiction and legal presumptions, because a lot of people feel that legal fiction and legal presumptions are perimeteria the same, but there's a difference between them. And since, as we all say that certain aspects, we are all from the common law, a lot of sessions and all laws journeys have started from the common laws as such. And as usual, when Mr. Shanghar, Mr. Mukant, and a lot of resource persons who are very popular and who were shared by Adi Lakshmi Logamurthy under the aegis of the legal elite, we thought, why not bring Mr. Shanghar? I was sharing with him that he had been down with COVID, but the positivity of sharing the knowledge is what we all like, and not the positivity in the COVID tests. That's the entire this thing. Since we are already running behind the schedule, I will request Adi Lakshmi ma'am to share the insights, and then we will talk on the legal fictions through Mr. Shanghar Murali. He has promised to share the notes. We will share it on the WhatsApp and the Telegram groups. Over to you, ma'am.
Thank you so much, because Beyond Law CLC and Legally Kills the Light is uniting after a very long time. Thanks to Shanghar Murali sir for taking a very nice topic, legal fiction, today. Sir was very famous down south previously. After this COVID-19 online platform, he's been taking almost through the length and breadth of India. The Kerala Bar Council, where he takes sessions, are excellently good, and your Beyond Law CLC and many other platforms. He's a regular with the judicial academies down south in Tamil Nadu, where he trains the honorable judicial officers there, and also he's training the aspirants of law, and he does not take even a penny to train all the people. He has been training so many people, and Legally Kills the Light is so proud and privileged having him on our platform. On this note, I welcome our most respected and beloved Shanghar Murali sir and his team, and he has a lovely team of juniors who are assisting us. I welcome every one of them, and Harita and Vakshi in particular, and other juniors. And I welcome Shanghar Murali sir. It's another time on the Beyond Law CLC along with Legally Kills the Light platform. Welcome, sir.
Good evening to all. First of all, I would like to share my thoughts. Why this particular topic, legal fiction, is selected by me? Because I am not aware of the proper perspective of legal perspective. In my earlier time of practice, I filed a suit for specific performance, and the defendant filed an application to reject my plaint on the ground of limitation. Then that application was allowed. Section 2 CPC defines degree, but it does not define deemed degree. It says order rejecting a plaint is also a degree, deemed to be a degree. At that time, I am not aware of the exact meaning of the deemed, what it means, what it conveys, why it is considered to be degree, why it shall be deemed to be a degree. So I filed an appeal, because order rejecting a plaint is a degree. So regular appeal alone will lie. I have filed the appeal. What I did, I affixed the court fee of only rupees 5,000, because I have paid the court fee of rupees 30,000 on my plaint, because the sale price is 10 lakhs. Then in the appeal, I have filed only 5 rupees as court fees. The registry has returned my plaint stating that under section 52 of the Tamil Nadu Court Fees and Suit Valuation Act, the proper court fee on the appeal shall be the same as affixed before the trial court. Then I said, sir, suppose my appeal is allowed, I am not going to get my main relief for specific performance. The appellate court will not grant a degree for specific performance in my favor. At the best, it will set aside the order passed by the trial court. That is, order rejecting my plaint alone will be set aside. So my opponent has paid only 5 rupees on the application to reject the plaint. So the proper court fee would be rupees 5, but it was not accepted. Then I asked the registry to post the matter before the regular court. Then I argued. The judge is not convinced. No. Once CPC says order rejecting a plaint is a degree, as against the degree, you have to file an appeal. Accordingly, you have filed the appeal. The payment of court fee on the appeal is as that of the payment of court fees paid on the plaint. You pay 30 rupees, otherwise I will reject your appeal. So at the time, I am not totally unaware of the rule of legal fiction. Though I was able to find out the proper court fee would be 5 rupees and not 30,000. Since lack of knowledge about the legal fiction, I was forced to pay 30,000 rupees. Thereafter, I did some homework. Later, I came to know that this is a legal fiction. Once a legal fiction is created, the court bounden duty is to ascertain the purpose for which the legal fiction is created. The court cannot extend the legal fiction beyond the purpose for which it was created. So that is the one reason for selecting this topic, legal fiction. And another one, recently, you might have come across the Supreme Court decision that the award passed by the Lok Adalat are not courts. Award passed by the Lok Adalat are not valid. This head note was widely spread through the social media. And I was also shell-shocked and astonished. How it could be? What is the purpose of enacting Legal Services Authorities Act? If the award is passed by the Legal Services Authorities Act, Lok Adalat, if it is not valid, where shall we go? Then I read over completely the judgment of the Supreme Court. It is on different point. Though legal fiction was not brought to the knowledge of the Supreme Court, in that case, the earlier decision of the High Court has applied the rule of legal fiction and came to a conclusion: legal fiction created in one act cannot be extended to another act. I am going to explain it in detail. So these are all the circumstances which forced me to select this topic, legal fiction. Unless the practicing advocate are not aware of the rule of legal fiction and its interpretation, we will lose our case. To know better about the rule of legal fiction and its interpretation, you must be very thorough in the principles of interpretation of statutes and General Classes Act. So the burning topic. Recently, the Supreme Court, last month, that is on 3rd February 2022, held Lok Adalat are not courts, its award is invalid. How? We will analyze and discuss. Now, let me start my lecture. Legal fiction. There are two kinds. One is statutory legal fiction, statutory fiction. Another one is non-statutory legal fiction. Definition. Literal meaning of the word fiction means it describes events and the people that are not real. Legal fiction definition. We cannot find the definition of legal fiction anywhere in any statute. But the interpretation of statutes, jurisprudence, General Classes Act, and the umpteen number of decisions of our Supreme Court made an attempt to define what is legal fiction and how it could be interpreted and to what extent. Now let us see one by one. Legal fiction, it is a rule. It is a rule assuming the existence of something that is non-existent. It is a rule assuming as true something That is clearly false. The word as if, wherever you see the word as if, then it creates a legal fiction. In almost in all physical enactments, namely the Income Tax Act, Sales Tax Act, GST, and other tax statutes, you can see the arrears of tax due and payable to the department shall be treated as if it were a land revenue. As if it were a land revenue. Why this word is used as if? Whenever the word as if is used, it creates a legal fiction. It is not a land revenue due and payable to the government. For the purpose of collecting the land revenue, Revenue Recovery Act is there. Only under the Revenue Recovery Act, the Tahsildar is empowered to collect the arrears of tax due and payable to the government, either by attaching the property of the defaulter or in some other way. But in all taxing statutes, the word as if it were a land revenue, in the sense only for the purpose of collecting the tax due under the particular physical enactment, it must be deemed to be a land revenue. As if in the sense deemed to be a land revenue. But it is not a land revenue in true sense. But for the purpose of collecting the same, it is the intent of the legislature. It is the intention of the legislature to consider, to deem it as a land revenue. So the word as if creates a legal fiction. The word as if, in fact, shows the distinction between two things, and such a word must be used only for a limited purpose. It must be used only for a limited purpose. The legislature is quite competent to create a legal fiction. In other words, to enact a deeming provision for the purpose of assuming the existence of a fact which does not really exist. A deeming provision will be made in a particular statute by the legislature. The legislature is the competent authority. It's quite competent to create a legal fiction by introducing a deeming provision. What it means, why the deeming provision is mentioned. The word deemed is usually used to enact a legal fiction. So whenever the word as if, it creates a legal fiction. Deeming provision is there is a legal fiction. When a thing is to be deemed something else, it is to be treated as that something else with the attendant consequences, but it is not that something. The word deemed in a great deal is used in the modern legislation. Sometimes it is used to give a comprehensive description that includes what is obvious, what is uncertain, and what is, in the ordinary sense, impossible. Sometimes it is used to impose for the purpose of a statute, to give an artificial construction of the word, of a word or phrase that would not otherwise prevail. Sometimes it is used to put beyond doubt a particular construction that might otherwise be uncertain. Deemed as used in the statutory definition to extend the denotion of the defined term to things it would not in ordinary parlance denote. It is often a convenient device for reducing the verbiage of an enactment, but that does not mean that wherever it is used, it has that effect. To deem means simply to judge or reach a conclusion about something, and the word deem and deemed used in a statute that simply state the effect or meaning which some matter or thing has the way in which it is to be adjudged. This need not import artificially or fiction. It may simply be the statement of an undisputable conclusion. Deem Deems means is of opinion or considers or decide, and there is no implication of steps to be formed before the opinion is formed or decision is taken. Of course, as in the opening, because this said whether legal fiction is equal is on par with the legal presumption. Legal presumption is something different from legal fiction. Under the Indian Evidence Act, there are certain things, certain circumstances under which the court may presume the existence of certain facts. The court shall presume the existence of the certain fact, and there must be a conclusive proof of conclusive presumption. You are all well aware regarding the legitimacy of birth of a child born within 240 days from the date of marriage. The father is deemed to be the father of the child. That is a conclusive presumption, I think, under section 112 of the Indian Evidence Act. But recently, the Supreme Court held, no doubt the child was born within 240 days from the date of marriage. So, as per the Evidence Act, he must be considered as the father. But he has pleaded that he has no access to his wife. He was away from the wife immediately after 1 day from the date of marriage. So even the conclusive presumption can also be set. Even the word shall presume, it is also rebuttable presumption. But legal fiction is something different. Once legal fiction is created, it's a bounden duty of the court to apply the same. It cannot interpret the legal fiction to suit the convenience of the facts of each and every case. But at the same time, legal fiction created in a particular statute cannot be extended to another statute. That is the interpretation. So legal fiction, it may be conclusive or rebuttable presumption, but depending upon the facts of each and every case. So once a legal fiction is enacted, created in a particular statute, the duty is to ascertain the purpose for which it is created. It would be proper and even necessary to assume all those facts on the basis of which alone such fiction can operate. When a statute says that you must be imagining a certain state of affairs, it does not say that having done so, you must cause or permit your imagination to boggle when it comes to the inevitable corollaries of the state of affairs. When law says A is deemed to be B, B is deemed to be C, then what about C? C is deemed to be A. C is deemed to be A. Then how to interpret the legal fiction? It's a greater art. We cannot interpret according to our whims and fancies. In order to interpret a particular statute, there are certain guidelines. There are rules. One rule is grammatical rule of interpretation. Word by word, you just interpret according to the grammatical sense. Another one is golden rule of interpretation. Golden rule of interpretation means it's a duty of the court to find out the spirit of the language used in the particular statute to find out its true meaning. The court must visualize what was transpired at the time of the enacting the law by the legislature. What is the object? What is the reason? The object and the reasoning of bringing this act and the background. If it is a beneficial legislation, court shall not interpret the word or the particular section in the statute, which is quite detrimental to the main object of the act. That is a golden rule of interpretation. Another one is hidden rule of interpretation, or otherwise known as mischief rule of interpretation. There cannot be any purposive interpretation to defeat the very object of the act. So once a legal fiction is created, it is a duty of the court to see the purpose for which the legal fiction is created. Why it is created? Whether it has been given any retrospective effect, or whether a legal fiction created in a particular statute can be extended to another statute. For example, state law borrowed certain provisions from the Central Act. Central Act. Then in the concurrent field, the state act will not have the effect of widening the definition of the Central Act. A famous, I would like to give my own illustration. Central Act, Civil Procedure Code. Under Order 14, Rule 2 of CPC, a pure question of law alone can be framed as an issue. That pure question of law must be relating to the jurisdiction or bar created by a statute. The advocates are often confused. Whenever any suit is filed, when a particular statute says the court has no jurisdiction, say for example, if any suit is filed challenging the notice issued under Section 13(4) of the SARFAESI Act, then the bank will immediately file an application under Order 7, Rule 11 of CPC to reject the plaint on the ground that this court has no jurisdiction. That would not be the proper procedure. Order 7, Rule 11 cannot be invoked for the purpose that the court lacks jurisdiction to entertain the suit. Then where we go? What are the procedure to be followed? When the court lacks jurisdiction inherently, when there is a total lack of competency of the court to entertain the suit, the only remedy open to the party aggrieved is to file an application under Order 14, Rule 2, requesting the court to frame a preliminary issue whether this court has got jurisdiction to decide the dispute. Under Order 7, Rule 11, from the averment in the plaint, if it appears that it is barred by a statute, then it is a ground to reject the plaint. Say, for example, if you want to file a suit against the government, you must give a 2 months notice. That is mandatory under Section, say, 80. If no 2 months notice, clear 2 months notice is not given, if any suit is filed without serving notice, 2 months notice, then the plaint will certainly include the allegation whether notice is given or not. When no notice is given, you may not allege that the notice is given. So when the notice is not given, no suit shall lie under Section 80. So the government defendant may file an application that the suit is not maintainable because no 2 months notice is given. That is a ground to reject the plaint. Please keep it in mind. If the plaint is rejected on any of the ground under Order 7, Rule 11, it may be for deficit court fees, improper valuation of the suit, and the want of cause of action, something like that. It does not preclude the plaintiff from filing a suit, fresh suit on the very same cause of action under Order 7, Rule 30. So the bar created under Order 7, Rule 11 means a key to enter into the lawsuit. But once the court lacks jurisdiction inherently, you cannot file an application under Order 7, Rule 11. You have to file an application only under Order 14, Rule 2, with a request to frame the preliminary issue whether this court has got jurisdiction or not. So that can be done. But Tamil Nadu Court Fees and Suit Valuation Act, Section 12 says, when the plaintiff is improperly valued or insufficient court fee is affixed, the defendant may file an application under Order 12, under Section 12, Subclass 2, requesting the court to frame a preliminary issue, whether the suit is properly valued or proper court fee is paid. Now there is a conflict between the two acts. One is Central Act and another one is State Act. Which act will prevail? Which act will prevail? Now, under Article 254 of Constitution of India, when there is a conflict between the State Act and the Central Act, the Central Act alone will prevail to the extent of repugnancy or inconsistency. But whenever the State Act is assented by the President of India, then it is otherwise known as a special enactment, and it will prevail over the Central Act. Generally, a specially best non-derogate. A special statute can override the general. So without knowing the principles of legal fiction, it is not possible for us to proceed a case. So, conflict, inconsistency, repugnancy. So we must be thorough in all the subjects, not only in Constitution, General Classes Act, principles of interpretation of statutes. So it must be remembered that what can be deemed to exist under a legal fiction are facts and not legal consequences which do not follow from the law as it stands. Legal fiction created in an act cannot be widened by rules. Once act creates a legal fiction, it cannot be widened by the rules framed under the particular act. Now, one of the classic example of legal fiction created in Civil Procedure Code, let us see. Section 2, Subclass 2 of CPC defines what is degree. As per this definition, degree adjudicates and conclusively determines the rights of the parties with regard to all or any of the matters in controversy. Therefore, a degree must satisfy the following test. Number one, there must be an adjudication. Such adjudication must have been given in suit. It must have determined the rights of the parties with regard to all or any of the matters in controversy. Such a determination must be of a conclusive nature. There must be a formal expression of such adjudication. So there must be a formal adjudication of expression of the court, which conclusively determines the rights of the parties with regard to all the controversies involved between the parties. Then the degree may be preliminary, final, or both preliminary and final. In a suit for partition, the first order passed by the court is a preliminary degree. It determines whether the plaintiff is having any share, how much share he is entitled, 1/3 or 1/4, 1/6. So it determines the rights of the co-sharers. preliminary degree. And the preliminary degree, the court will direct the defendant to divide the properties as per the preliminary degree and allot the particular share in favor of the plaintiff. If the preliminary degree orders are not complied with, then the plaintiff may file an application under Order 26, Rule 13 to pass a final degree. To pass a final degree. So, suit for partition, both preliminary and final degree will be passed. Suit on mortgage, both preliminary and final degree will be passed. Administrative suit, both preliminary and final degree will be passed. Suit for dissolution of firm and for addition of account, preliminary degree and final degree will be passed. So these are all some examples in which preliminary degree and final degree can be passed. Is there any degree? Is there any suit in which the degree is both preliminary and final? Only one suit. If a suit for possession and for recovery of possession is filed, the suit is decreed so far as the degree relates to the recovery of possession is concerned, it is final. So far as the degree relates to mean profit will also be awarded, but the court will pass an order. Then the quantum of mean profit will be relegated under Order 20, Rule 12 of CPC. Then it is preliminary. So this is the one suit in which the degree is reflecting both preliminary and final. If any compromise degree is passed in a suit for partition, allotting the share and dividing the property and causing delivery of the same, then it will also be a both preliminary and final. Now, the definition does not end there. It went on saying, an order rejecting the plaint is deemed to be a degree. Order rejecting the plaint is deemed to be a degree. What is the basic distinction between degree and order? Degree is formal expression of an adjudication. Order, formal expression of a decision. That is the definition. So degree can only be passed after framing issues, after conducting trial, after hearing the argument, a degree will be passed. Suppose any order is passed in an interlocutory application, whether that order can be construed as a degree. CPC says order rejecting the plaint is a degree, is deemed to be a degree. The word employed is deemed to be a degree. Here a legal fiction is created. Legal fiction is created to the extent that if an order rejecting the plaint is passed, then it shall be deemed to be a degree. All right. Deemed to be a degree. There are certain other provisions under the CPC itself. If any, suppose, you have filed an application to reject the plaint, if it is allowed in the sense plaint is rejected, then it is a degree. Application filed to reject the plaint is dismissed, then it is not a degree. It is not a degree. Order rejecting the plaint is a degree. Order dismissing the petition filed to reject the plaint is not a degree. You must know the sharp distinction. Then what is the remedy available to the parties aggrieved in both the cases? In the former, if the plaint is rejected, the remedy open to the aggrieved plaintiff is to file an appeal under Section 96. In the latter, if the application filed to reject the plaint is dismissed, the remedy open to the defendant is to file a civil revision petition under Article 227 of the Constitution of India, because it is not an appealable order. So what are all the appealable order under the CPC? Order 43. Order 43 illustrates what are all the orders which orders are appealable. So when the order is not an appealable one, the only remedy is to invoke Article 227. Likewise, if any order is passed under Section 144 of CPC, it shall be deemed to be a degree. 144, you are all well aware, restitution of the property, suit property. Suppose you filed a suit for recovery of possession. Suit was decreed. Then the defendant has to file an appeal. But he was unable to get an order of stay of execution of the lower court degree. Then immediately he will levy the degree in execution and proceed with the execution proceedings. After the appearance of the defendant, it is the accustomed practice of the executing court to ask the respondent, have you obtained stay? No stay. Okay, call the case next month and to produce stay order. Otherwise, the matter will be proceeded. Order 41 is very clear. Mere pendence of appeal does not amount to stay the execution of the degree. Unless the lower court degree is stayed, it is always open to the executing court to proceed with the case. So appeal is filed, no stay. Then EP will be proceeded. Suppose in the EP delivery is ordered, delivery was taken. Later the appeal was heard. Appeal is allowed. Appeal is allowed in the sense you need not deliver the vacant possession of the property, suit property to the plaintiff. But as per the order of the executing court, he has taken delivery of the property. Can you be compelled to file a suit for recovery of possession against a plaintiff? Not so. You have to file an application under Section 144, not before the appellate court, before the court of first instance. You have to file an application before the court of first instance, trial court, under Section 144. The plaintiff who has filed a suit for recovery of possession, suit was decreed. As against the degree, I prepared an appeal, but unfortunately I was not able to get the stay that was taken undue advantage by the plaintiff, and he has taken deliver the property from the executive court. Later, my appeal was heard, and on merits, my appeal was allowed. In the sense, I need not deliver the vacant physical person of the property, but it was delivered to the plaintiff as per the order of the executing court. Now I am entitled to restore my possession. That is the restitution application. If your application is dismissed, then it is deemed to be a degree. If your application is allowed, then it is deemed to be a degree. The only remedy open to the aggrieved party is to file an appeal under Section 96 of CPC. Then any order passed under Order 21, Rule 58.4, as if it were a degree. The word used is as if. As I said earlier, whenever the word used as if deemed to be, then it creates a legal fiction. So Order 21, Rule 58, subclass 4, it is otherwise known as claim application, claim petition. When the judgment debtor property is attached by the executive court, the person having title over the same, he can suppose possession is taken during the pendency of if the suit is for recovery of possession, if possession is taken illegally, the only remedy you have to file a suit under Section 6 of the Specific Relief Act, summary manner. You can recover. Then your property is illegally, by mistake, wrongly attached by the executing court under the guise that it belongs to the judgment debtor. You can produce your document stating that this is my property, it has been unnecessarily attached. It is not the property of the judgment debtor. And judgment debtor brother may say, this is the property allotted in my favor in the partition. My brother has not been given any share in that property. But that property, my property which fell to my share was attached. You can make your claim. So any person interested in having interest over the property attached can file an application under Order 21, Rule 58. If it is proved that the third party claim petitioner is having title over the property and the judgment debtor has no saleable interest in the property, definitely this executing court will allow your application and order the degree holder to attach the property of the judgment debtor. So the attachment will be raised. If it is found that the claim petitioner's claim is bogus, then that application will be dismissed. So whether it is claim petition is dismissed or allowed, as if it were a degree, so legal fiction is created. Then you have to file an appeal under Section 96. Then Order 21, Rule 46B, 46C, 46E, these are all relating to garnishing. If any is passed under Order 21, Rule 46B, 46C, 46E, it shall be deemed to be a degree under Order 21, Rule 46H. Resistance. If any order is passed under 21, Rule 97, resistance or obstruction, or under Order 29, Rule 99, or Order 21, Rule 101, all shall be treated as deemed to be a degree under Order 21, Rule 103 of CPC. Then two more acts also create legal fiction. One is under Section 57, subclass 2, small d of Transfer of Property Act. Discharge of encumbrance or sale. Suppose property is auctioned by the court, subject to some encumbrances. The auction purchaser may approach the competent district court to raise the encumbrances by paying the amount. District court alone is the competent court to pass such an order under Section 57 plus 2D of the Transfer of Property Act. If any order is passed, then it shall be deemed to be a degree. Likewise, under the Partition Act, if any order is passed under Section 234, then all the orders shall be deemed to be a degree under Section 8 of the Partition Act. Now, can you state the stage on which the provisions of Partition Act can be invoked? Partition Act can only be invoked at the moment, only at the time of final degree application, only when the advocate commissioner appointed by the court files his report that the property is not capable of division. The property cannot be divided by metes and bounds. Then only the provisions of the Partition Act containing only 10 sections will apply. Whether a person is having might of the share, he can compel the court by directing the other party to sell his share and paying the overtime. When the two co-sharers are quoting the very same highest price, then the property will be sold in public auction. So any order passed under Section 2, 3, and 4 of the Partition shall be deemed to be a degree under Section 8 of the Partition Act. So these are all some extensions. Legal fiction is created in CPC. Now, coming to the first illustration which I had better experience. Suppose you filed a suit for specific performance. Say for sale price is 10 lakhs. So the proper court fee as per the Tamil Nadu Court Fees and Suit Valuation Act now is 3% on the subject matter. So for 10 lakhs, you have to pay 30,000 as court fees. Accordingly, you have paid 30,000 as court fees and filed the plaints. The suit is for specific purpose. The defendant entered appearance and filed an application, Order 7, Rule 11 of CPC to reject your plaint. On the ground, your suit is barred by limitation. Of course, it is a duty of the court under Section 3 of the Limitation Act to see whether the suit is in time, whether or not the plea of limitation is raised by the defendant. Because it is a bounden duty of the court to see whether the suit is in time or not. Period of plea of limitation, the advocates are often confused whether it is a mixed question of law or fact or pure question of law. By taking into consideration of each and every fact, sometimes the plea of limitation is a pure question of law. Sometimes it may be a mixed question of law and fact. Suppose my plaint is rejected, stating that the plea of limitation is a pure question of law. Okay, as per the legal fiction created in Section 2.2, the order rejected the plaint shall be deemed to be a degree. So once it is deemed to be a degree, what are all the provisions applicable to degree that has to be followed? So as against the original degree, I got to file an appeal only under Section 96. So as against the order passed under Order 7, Rule 11 to rejecting my plaint, I have to file an appeal under Section 96. All right. So in strict adherence to the legal fiction created, I have filed my appeal. Then the question is payment of court fee. As per Section 52 of the Tamil Nadu Court Fees and Suit Valuation Act, the proper court fee on the appeal is as that of the trial court fee. Before the trial court, you have paid 30,000. Now you have to pay 30,000 as court fees to entertain your appeal. Otherwise, the registry will return your appeal. Now the legal fiction is created, then how to interpret this? Whether is it the intention of the legislature by creating the legal fiction that the order rejecting the plaint shall be a degree in all purposes? That is not so. That is not so. Why it is deemed to be a degree? Degree conclusively determines the rights of the parties. Order rejecting the plaint also conclusively determines the rights of the parties. So when the both are same, when both is when the latter, the order rejecting the plaint is deemed to be a degree, necessarily I have to file an appeal. But what about the payment of court fees? What was my application? What was the application filed by the defendant to reject the plaint? What was the court fee paid by him under Article 1 of Schedule 1 of Tamil Nadu Court Fees and Suit Valuation? Just 5 rupees. So by affixing 5 rupees, he has filed an application to reject my plaint. Accordingly, thereafter my plaint was rejected. Now, as against the said order, I have preferred the appeal. What was paid him as court fees? 5 rupees. Can I be compelled to pay 30,000 instead of paying 5 rupees? Now, assuming for a moment, my appeal preferred against the order rejecting my plaint is allowed. Can I get the main relief of degree for specific performance? I can't. When my appeal is relating to getting the main relief of degree specific performance, then there is a meaning in saying that I have to pay the court fee which was paid before the trial court. What is my appeal? The subject matter is different. I am not going to get my main relief. At the best, the court will allow my appeal in the sense the order rejecting the plaint is set aside, then the case will be returned to the trial court, then automatically my case will be restored from the stage on which my plaint was rejected. That's all. So under those circumstances, the legal fiction created under Order 2, Section 2, Subclass 2 of CPC cannot be extended to another act. Another act means Tamil Nadu Court Fees and Suit Valuation Act. Tamil Nadu Court Fees and Suit Valuation Act does not create any legal fiction. It is not stated order rejecting the plaint come under the purview of the appeal. The whatever the court fees paid before on the plaint shall be the same in the appeal. It does not say so. So here the interpretation of legal fiction came in. What it says, legal fiction is created under section 2.2 of CPC. It cannot be stretched, it cannot be extended, it cannot be invoked to another statute, namely Tamil Nadu Court Fees and Suit Valuation. Recently, our Madras High Court in Ratan Chand Sharma versus Vinayaga Export and Imports, reported in 2017, 6 MLJ, page 75, has held that the proper court fee is only 5 rupees and not the court fee paid on the plaint. Though it was not brought to the knowledge of the court regarding the legal fiction, but the irresistible conclusion must be is this. This is the legal fiction created by the legislature under section 2, subclass 2 of CPC. It cannot be extended to Tamil Nadu Court Fees and Suit Valuation Act because by allowing the appeal, the plaintiff will not get the main relief of degree for specific purpose. So, it is a bounden duty of the court to ascertain the purpose for which the legal fiction is created. It cannot travel beyond that scope. Cannot travel or beyond that scope. Now, yes, 2017, 6 MLJ, page 752. I will circulate my notes in PDF. 2017, 2017, 6 MLJ, page 752. Then coming to the latest decision of Supreme Court. On 3/2/2022, this month, on 3rd, the Supreme Court gave a very important landmark judgment. Lok Adalat are not courts. The award passed by the Lok Adalat are invalid. Please, participant, please, you can share the question after my session is over, then I will answer. On 3/2/2022, in New Workla Industrial Development Authority, Noida, the Supreme Court has held that Lok Adalat are not courts. The settlement degree or award passed by the Lok Adalat are invalid. This head note is widely spread through the social media. Like me, advocates are shell-shocked and astonished. How it could be? Then what is the purpose of enacting the Legal Services Authorities Act 1887? Then why we are unnecessarily breaking our head to obtain a compromise degree? If it is not valid, then where we go? Then is it not a court? Unfortunately, we failed to read the judgment of the Supreme Court in its entirety. That is the case. In Noida, the government has acquired a piece of land for public purpose. Say, for example, there are 50 owners whose lands are acquired under the Land Acquisition Act. Then award was passed by the referring officer. If the land owner is not willing to accept the award amount, he can file an application with section 18 to the district collector for reference, for referring the award to the land acquisition tribunal, namely the subcourt, to fix the compensation, to redetermine the compensation. Normally, you are all well aware, in land acquisition matter, the RDO will fix very minimum rate as market value. If it is in the case of property tax or some other taxing statute, then he will fix the rate which is higher. So in the matter of land acquisition, a low amount will be fixed as a market price. So once the reference is given to the district collector in turn refer the matter to the land acquisition tribunal to redetermine the compensation. So out of the 50 members, one of the members filed an application for reference under section 18. Thereafter, the matter came to the land acquisition tribunal. In the land acquisition tribunal, the judge asked the referring officer and the claimant to go and settle the matter before the Lok Adalat. In the Lok Adalat, somehow or other they reached a compromise. The land acquisition officer has agreed to fix the enhanced market price as compensation. Accordingly, award was passed by the Lok Adalat. Then it came to the knowledge of the other owners who have not filed their application for reference. Then after coming to know about this award passed by the Lok Adalat, enhancing the compensation, they have filed an application under section 18 of the Land Acquisition Act before the district collector for redetermination of the same by the tribunal. Then the district collector said, Lok Adalat is not a court. Award or degree passed by the Lok Adalat will not bind me and as well as will not bind you. You cannot take undue advantage of the degree passed by the Lok Adalat, compelling me to redetermine the compensation. Then that application was dismissed by the district collector. Then matter went to High Court, Lucknow. High Court said, same piece of land, there are 50 owners. One of them filed an application. Referring officer has agreed to fix enhanced the compensation. So why not the same is applicable to other owners whose lands are acquired? Then order passed by the district collector was set aside, and the collector was directed to redetermine the compensation on par with the award passed by the Lok Adalat. Then this matter went to Supreme Court by way of SLP. Leave was granted. Then it has been subsequently converted to civil appeal. Some of them are not aware. As against the order of the High Court, you cannot file appeal before the Supreme Court straight away. You have to seek the leave of the Supreme Court. Special leave. Once special leave is granted, then your special leave petition will be automatically converted into civil appeal as in the case of civil matter. Then it will be converted into criminal appeal as in the case of criminal case. That is section Article 133 and 136 of the Constitution of India. Suppose your SLP is dismissed, it does not prohibit the High Court to review the order. Normally, review application will lie when there is no appeal is filed. But in the case of SLP, it is not an appeal, it's only a special leave. Once special leave petition is dismissed, you are perfectly and justifiable in filing an application for review before the High Court, which passes the order. All right. Now the Supreme Court said, award of the Lok Adalat is not on merits. our Lok Adalat are non-adjudicatory functionaries. There is no order on merits. Only based on compromise, based on the suggestion given by both the parties, it will be reduced in the form of a degree, compromise degree. But whereas under section 28A of the Land Acquisition Act, redetermination of the compensation can only be made as per the degree passed by the Land Acquisition Tribunal. Here, award is by the Lok Adalat, not by the Land Acquisition Tribunal. If any degree order is passed at Land Acquisition Tribunal, that is a degree. Then compensation can be redetermined under section 28A. But here, it is a Lok Adalat. One may ask me, sir, whether the plea of promissory estoppel is applicable. So, same set of facts. One landowner is entitled to get more compensation. Why not the others? But law, I don't know the legal luminaries who said law is an ass. When you go in front of it, it will kick. When you go behind it, it will also kick. There cannot be any legalities or ethicalities. Though it is not brought to the knowledge of the Supreme Court, Honorable Supreme Court, that the legal fiction created under the Legal Services Authorities Act. The Legal Services Authorities Act, Section 20 clearly states that any order passed by the Lok Adalat award shall be deemed to be a degree as if it was passed by the Civil Court. So a legal fiction is created under Section 20 of the Legal Services Authorities Act. That award shall be deemed to be a degree passed by the Civil Court. Whatever Section 28A of the Land Acquisition Act says, order passed by the Civil Court. When this is deemed to be a Civil Court, then why not the award will not bind you? Here, the rule of interpretation will apply. In order to interpret the rule of legal fiction created in one statute cannot be extended to another statute. So, Section 28A of the Land Acquisition Act is very clear. It is very, in an unambiguous terms, it has been specifically stated the compensation can only be redetermined on the basis of the degree passed by the Land Acquisition Tribunal or Civil Court. No legal fiction is created under the Land Acquisition Act. Where the legal fiction is created? Only under the Legal Services Authorities Act. Why this legal fiction is created? Suppose any degree award is passed by the Lok Adalat. Suppose both the parties entered into a compromise. There are certain corresponding obligations to be performed. When any one of them failed to perform their obligation, that the party aggrieved by taking advantage of the compromise degree may approach the court, namely the executing court, to execute the compromise degree. So the legal fiction created under Section 20 of the Legal Services Authorities Act is only for the purpose of levying the compromise degree in execution and not beyond that. So how the legal fiction created in one particular statute can be stretched on or extended to another statute? It can't be. Earlier, one very landmark judgment that is reported in 1987 3 SEC 655, State of Karnataka versus K. Gopalakrishna Shannai. Unfortunately, it was not brought to the knowledge of the Supreme Court. Though the Supreme Court said Lok Adalat degree or not Civil Court degree or not is invalid. But legal fiction is created that has not been brought to the knowledge of the Supreme Court. But recently, the Bombay High Court in Srimati Uma Devi Rajkumar versus District Collector Solapur. This is the order dated 24/6/2021. Very same subject matter, it was dealt by the Honorable High Court of Bombay, wherein the Bombay High Court has said legal fiction created under the Legal Service Authorities Act cannot be extended to the Land Acquisition Act. Then legal fiction, another one important judgment is State of Mysore versus Fakur Sahib, Babu Sahib. This is reported in 19. Okay, I will tell you the citation. In this case, first class magistrate Badami. Badami is a town in Karnataka. Magistrate refused to take cognizance of the charge sheet filed by the police. On the ground, Mysore Ordinance 4 of 1970 came in with retrospective effect from 1/10/1970. It deleted the word police. If the report is submitted by the excise officer, then it will be taken cognizance by the concerned magistrate. Earlier, either by the excise officer or by the police officer's report, the court can take cognizance of the subject matter. But the word police is deleted by the Mysore Ordinance Act, Mysore Ordinance 4 of 1970. It came into effect with retrospectively from 1/10/1970. Based on this ordinance, 21. One second. Sorry, section 21 of the Legal Service that says that all awards shall be deemed to be a civil court degree. 21. By mistake, I said it is section 20. So the Badami magistrate refused to take cognizance of the charge sheet filed by the magistrate. Then the state preferred a revision before the Sessions Court, Bijapur. That was also dismissed. Then revision before the High Court was also dismissed. Then finally the matter went to Supreme Court. After obtaining special leave, the criminal appeal was entertained. Pending revision before the High Court, again Mysore Act 1 of 1971 came in. It repeals the Mysore Ordinance and state it will retrospectively take effect from 1/7/1970. So when the subsequent act was given effect retrospectively, the legal fiction created therein must be given retrospective effect. So finally, the Supreme Court said the legal fiction must be given retrospective effect, and this is the proper interpretation of the legal fiction. So accordingly, the criminal appeal was allowed. So these are all some instances of legal fiction created by the legislature in particular enactment. And there are 23 Supreme Court judgments are there on this topic, legal fiction. The complete study of the Supreme Court judgment, I will circulate it, will give you a clear picture about the rule of legal fiction and how to interpret the legal fiction. Apart from that, you must know the principles of interpretation of statutes and the General Classes Act. Otherwise, it is impossible to know about the rule of legal fiction. Because now it is over to you.
Yes. That was a spellbound effect. Mr. Rao says, in case of possession was taken during the pendency of a suit for injunction is pending, even the pendency of an ad interim injunction is there. This question is incomplete.
Question is, suit for injunction or recovery of possession?
Interim injunction is there.
Suit for interim injunction, interim order was granted, but he was dispossessed.
Nothing forthcoming.
Yes. When he was dispossessed, his remedy is to file a petition under Order 39 Rule 2A for the disobedience of the order passed by the court. He can attach the property of the defendant, or he can ask to arrest the respondent, that is for disobedience of the order, or he can move the High Court under Section 10 of the Contempt of Court Act for the violation of the order passed by the subordinate court. So in both under Order 39 Rule 2A and Contempt of Court, the party who is at fault will be punished and his property will be attached and you can get compensation. But in order to recover the possession of the property, necessarily you have to file a suit for recovery of possession under Section 6 of the Specific Relief Act along with the damages. That's a proper course.
I think that was the only question. I'll ask. No. I'll ask.
Ask the reader to share their questions in the chat box.
Yeah, we will share that. It is one name of the law book of India defining legal fiction.
Pardon?
Is there any book where the definitions of legal fiction, etc.?
There is no book on the topic legal fiction. There's no book.
Yeah.
No book is published so far regarding the legal fiction. It is only in the decision of the Supreme Court and the interpretation of statutes.
What is Mysore case law?
Case law. Yes. 1 second. Mysore case law. (1977) 1 SEC page 666. 1977 1 SEC page 666. State of Mysore versus Pakrusa Babusha Karanji. I will share my notes. No.
Sanjita says, in my opinion, such as LSA, no dispute would arise from a decree, but the matters relating to the other acts like Motor Vehicle Act, etc., will only be referred to be a deemed decree. Should be applicable to the other acts. What is your view on that?
Pardon? Please repeat the question.
She says, in my legal opinion, as such on LSA, no dispute would arise for decree, but the matters relating to the other acts like Motor Vehicle Act only would be referred to the deemed decree. Should it be applicable to the other acts also? What is your view?
It cannot be applied to another statute. That is why I said the interpretation of rule of legal fiction, whenever illegal fiction is created in particular statute, it is applicable only to the particular statute. It is well within the four corners of that particular statute. The legal fiction created in one statute cannot be extended to another statute.
Yeah. So we have those questions. I will ask Adi Lakshmi to share her thoughts.
Thank you so much, Vikas. It was a different topic. Sir was telling there's no book in this particular subject. I think the first book will be by Shanghar Murali, sir. The little note will become into your major book, and we are ready to publish it for you also, sir. It's a very excellent, different topic. And I thank Vikas for selecting this topic and also bringing in Team Legally Kills a Light along with you as a knowledge partner. And Shanghar Murali sir's topic always creates a lot of interest in our mind. Even senior advocates and honorable judges come and join in. In fact, 2 of the district judges from Tamil Nadu is connected in this platform. It was a really excellent session. We all enjoyed and enriched, and this Sunday was a really good one in acquiring the knowledge, sir. Thank you so much, sir. And I should thank the juniors, Vakshi and Harita, for helping him out in getting all the citations, typing it out and circulating it.
Both Harita and Vakshi is absent today. It's only Adi.
Okay, but in absence. Yeah, in absence, all
he says under also, the deeming fiction of law, they are
deeming fiction. Legal fiction is created.
yeah, deeming fiction that they had their major contribution.
Yes, yes,
And
yes.
I can only say the session had the different spectrums under the fiction of law.
Yes.
And Mr. Shanghar Murali has, as usual, taken the session spot on. And the fact that the session went off well, there cannot be any fiction, but that is a reality. Everyone stay safe, stay blessed. Thank you.
Thank you.
Thank you. Thank you.
Thank you.
Thank you
Thank you.
all. Thank you.
Thank you, Vikasji. Thank you.
Thank you.
Harish, madam. Thank you for all the participants.
Thank you, sir. Thank you so much.